Hello, I'm Stephen Cooley and welcome to Stephen Cooley Real Estate Show. I'm very excited to be here on site with Tracy Reynolds at your Fort Mill office. Tracy Reynolds is a local real estate attorney and doing a great job for us in closing all these real estate loans for our buyers and sellers. First of all, I want to thank you, Tracy, for doing a great job. It's always a pleasure to have you on the show and for you to give great legal advice to our viewers. And so I want to just hit some first things with you, if that's okay. When people buy property, they have the opportunity to have it deeded many different ways.
Correct.
And that's a great time to get it done so you don't have to go back and do it. And it has a lot to do with if there's multiple owners, if one passes away. So do you mind hitting those with us, please?
Sure. So the two most common ways are tenants in common, which is each person has an undivided 1/2 interest or whatever the interest may be. So if that person or one of the individuals were to pass away, it would go through their estate and out via the terms of their will, if no will, state statute. And then the second most common would be the setting up joint tenants with the rights to survivorship. So it can be multiple owners or two. We typically see it with husband and wife. So if the husband or the wife were to pass away, by filing of the death certificate, the property is vested in the it's put on notice and the property is vested in the surviving spouse.
And I want to just emphasize how important that is, because if two people buy a property and if you want the other person to own it in its entirety, if you pass away, then you need to go with the joint tenancy.
That's right.
And if two people own a property and one passes away and you want it to go through their will,
Right.
to their heirs,
Right.
then you go with the tenancy in common. And with a married couple, if you've got the tenancy in common, it's going to go to the children, so the children will now become owners of the home.
Exactly.
with the other spouse. So, and if your business partner is buying a rental property or something, just different decisions to be made. And I just have to say is most of the time this is not covered to the degree that you cover it with people. So I really want to thank you for that, because it really makes a big difference when they go through an estate and try to dispose of the property.
Right, yes, and that is part of my job. We help with the loan closing and that part of the process, or the transaction overall, and people may see that as being our large involvement, but our main job is to make sure title is clear, or you understand why it might not be, and two, how you hold title, understanding that, and then of course other tax exemptions and other things. That's our job to make sure you understand that.
Because a lot of times, a lot of our buyers are buying a property together. A lot of times they're buying a property for their parents. You're seeing a lot of that these days. Parents buying property for children, people buying property that aren't related just to invest in property. And so all that can be handled at the closing if you understand it, and you do such an amazing job explaining that to people. So I really recommend folks talking to Tracy before you close on property. Let's just talk about the other thing is, all property in the state of South Carolina is assessed at 6% other than your primary residence, and that can make double to triple the tax bill.
Exactly.
And so it all starts out at 6%, and you've got to apply for it to be reduced if you're owner occupied. So do you mind just sharing with people how important that is?
Sure, yes. When a sale is transferred or property is transferred through the courthouse, any tax exemptions that have been placed on that property are lifted, and the new owner has to start all over. So you have to apply for it to be taxed as your primary residence. If it's farm usage, you have to apply for agriculture or farm usage. If you're over the age of, or you're 65 and lived in the state of South Carolina, you have to apply for your homestead. So lots of times people think that it defaults to this, but it does not. You have to make application for those, and there's certain deadlines that you have to meet to have those be applied to your property.
And this doesn't automatically happen. So there's people in our area buying property, closing on property, using it as their primary residence, and being taxed at this 6% because they did not follow the proper channels and get it filed as an owner-occupied residence. And I just want to say you are amazing at explaining that to people and following up with the people who close with you to make sure they file that correctly, because it can make the difference between, I know in my personal home, my taxes are around $3,000 a year. If it wasn't owner occupied, that'd be almost $9,000. So the difference between $3,000 and $9,000 is filing this if it's owner occupied.
Right, and I close loans every month where sellers walk in and did not know about that exemption and have been paying this higher rate for several years. Same with the holding deed, not holding deed, holding the property with joint tenants with rights to survivorship, or however may be best for the individuals. It's something that you need to discuss at the time of closing or before closing, particularly if it's a special circumstance with a parent or a child. There's things that you would probably not know that the attorney can help advise.
Absolutely. I put a property on the market and they'd been paying the higher taxes for 9 years. And the taxes were about $9,000, could have been about $3,000, and they had moved from up north, and they thought $9,000 was normal. So they didn't know it wasn't normal, but it was so they were overpaying that for 9 years. And so again, Tracy's amazing at explaining that to people. Another thing I want to hit on is surveys, because people have got out of the habit of having surveys.
Right.
When I got into the business a long time ago, everybody got a survey. And so a survey shows where your lot lines are. Some people call them a plat, some people call them a survey, but it shows where your lot lines are, and it shows if anybody else's property sits on your property.
Right.
Because they can actually claim ownership of that over a long period of time if they sit on your property. And we're seeing a lot of that with driveways, and we're seeing a lot of it with townhomes now. So hit on that real quickly, please.
Well, and to touch on what you said, years ago, surveys were required for lenders to have coverage. So lenders would require the buyer to get a survey. Later, title companies decided to give coverage to lenders, but not to the buyer. So this is key, because the lender will have coverage as if you had purchased a new survey, but the buyer does not. So as far as a townhome, if when the developer went out to build the townhomes, it was better to move over 6 feet, there may have been a survey done, and it may have been recorded. But at the same sense, it may not have been referenced in the previous deeds, as the attorney transferring originally from the development didn't know that there was a revised subdivision plat. So if you perform a new survey, you would know, does my townhome sit on my tract of land, or has it been moved over? So that there's 6 townhomes that have been moved over to the left, each owning a portion of the other person's property.
And we have seen that locally in our area
We have
happen.
seen that.
Absolutely.
So I think that a survey is one of the most important things. Having said that, if you get a copy of the seller survey and it was completed in 95 or 2000, and it shows the house and the driveway and anything else you may be concerned with, you're probably good. But if there's not been a survey, which we see a tremendous amount of the time, if there's been a piece of property that's been deeded away, swapped with the neighbors.
Or the home added onto, driveways
Yes.
added, swimming pools, fences, outbuildings.
We oftentimes see properties where a garage may have been added, and the restrictive covenants may restrict how the garage can face, where it can be located. Those are all things we cannot see unless the client does obtain a new survey.
Absolutely. I just want to say that it is the buyer's option to pick your closing attorney. It's not up to the realtor, it's not up to the lender, it's not up to anybody other than the buyer. So I highly recommend buyers watching this show to ask for Tracy Reynolds to close their loans, because then they're not going to have a problem with how this is titled. You don't have a problem with surveys. You're not going to have a problem with the tax exemption. So I could not recommend you anymore. You do my personal stuff and most of our clients' things. Tracy, tell folks how to reach you.
You can reach me by calling my office at 803-328-0150, or you can email our office as well at info@threynolds.com. My website is threynolds.com. It has all the information about joint holding title, joint tenants with rights to survivorship. It has all the exemptions for the taxes. It has a lot of information that would help you prepare for your upcoming closing.
Absolutely, and we're filming today in your beautiful Fort Mill location. You're also located in downtown Rock Hill, so they can pick whichever one's closest to their work or home, so you make it easy for them.
Thank you.
Thanks for always doing an amazing job for us and giving great expert advice here on our show. So thank you so much. Please stay tuned. We've got beautiful homes for sale in your area, and we'll be right back. I hope you've enjoyed watching the Stephen Cooley Real Estate Show. If you're interested in advertising your business on the program, please give us a call at 803-326-2777. Join us next week for more discussions on real estate topics and help in finding your perfect home. Thanks for watching.